Hello, YouTube. I'm Vince White. I'm an employment attorney, and I want to make a follow-up to yesterday's video. You may have watched or not watched yesterday's video. So essentially someone asked me, "Hey, I think attorneys are telling me my case isn't valuable because it's a he said she said case, and I want to know if that's true." And basically, my take on that video was like, most cases in 2022, or he said she said, people have gotten more clever, and like it's on us as attorneys to believe that we can get a finder of fact, a jury, a judge, to believe our client, right? We can't just be cherry picking the very best cases. But I already made a video on that. What I also wanted to add was there's two additional things that this whole he said she said narrative really didn't take into account. Now, the first one is it costs a lot of money to defend an employment law case. A lot of money. Like, defense attorneys, they're going to be billing, I mean, if it's like Jackson Lewis, like 300, 400, 500 an hour, because they're very budget option in terms of firms. I'm not saying they're bad, I'm just saying they're extremely affordable if you've done a bad thing in the workplace. Sometimes you got to sell yourself cheap, right? I kid. I'm Jackson Lewis. You guys, you're the best. You guys are great. And they are a great option if you looking to get a case settled. I can't think of a more economical firm to do that for you. But at the low end, 300, 400, 500 an hour. At the upper end, so I hear, right? At the upper end, 1,100, 1,200, 1,500 an hour, right? And or even more in a couple of boutique firm cases, right? Defense firms don't come cheap generally, and that money gets billed out fast, super fast, right? I mean, if the plaintiff's attorney is doing her or his job, the case should be moving at a fast and aggressive clip, and that is going to generate tons of work for associates who want to bill the employer for their time. Of course, defense partners do almost nothing in most cases. There's certainly, I can think of a couple partners right now who do a whole bunch, but so you're moving the case, generates a lot of billing. The employer, just in the agencies, might spend $20,000, $30,000, $40,000. And then through a federal litigation, I mean, we are talking to the tune of hundreds of thousands of dollars, right? So I'll give you an example. I can specifically remember I had a case where defense counsel had been brought. The defense firm brought in like a trial guy at the end, which he wasn't too familiar with the case, and I didn't really understand what he was trying to do. So he basically took the position, "Oh, we're not gonna settle unless you take this offer," because I told my client that I would flat rate the trial for them for 80 grand. And I was like, well, thanks for telling me that, guy, because I think you had like 60 grand on the table. So now I know 60 is not where it's at. And at the bare minimum, your client's probably thrilled to pay me 80, because they could pay you the 80 and still lose that hearing because this is a good case, and they could lose a lot more than 80, and still have paid you 80. So like, the concept that you're bragging about flat rating, like, I gave them a good deal so that they're not going to settle with you. It's like, well, I don't want your 60. I don't think we want your 80 either. But frankly, you just told me, you moron, that the 60 is nonsense, and at the bare minimum, we should be at 80, right? Like, the whole thing was silly, and we were not interested, right? We wanted hundreds of thousands of dollars in that case. Without any identifying characteristics, we want hundreds of thousands of dollars in that case. But it was just so silly that this guy was like, yeah, take 60, because I'm going to flat rate the hearing for 80. It's like, okay, well, you're not pricing in even your own bill, let alone the risk of going forward on this case and potentially losing big, let alone the press, which brings me to my second point about he said, she said cases. I am often accused of trying cases in the public eye, court of public opinion, right? I do not do that. It is not my fault that my cases are fantastically interesting and reporters write about them. But if reporters write about my cases, you can be darn sure that I'm going to do my absolute best, with our PR team and my own efforts, to make sure that we control that narrative. Why? Because it's valuable to our client. And what's valuable to our client is valuable to us, because that is how we show that we help people and we get more clients. But also, more importantly, every dollar we win our client is money in our pocket. That's how this industry works, right? So if we win our clients more money, so too does more money go into my pocket. I like my pocket. I like it better when it's full. So obviously, if there's a court of public opinion rolling on a case, if there's press, if there's media, if people are getting on social media, whatever it is, yeah, full court. We're playing full court defense. We're going to control that narrative. It's not generally that hard because defense attorneys are terrified of that stuff. And listen, there's definitely personalities who are not. I can think Mercedes Cohen of Fox News fame is a defense attorney who will play full court defense and will try to murk you in the press, right? Just stabby, does great work, right? If you ever need a defense attorney, she might be it if you can afford it, right? Now, that's incredibly rare. It's probably true of the plaintiff's attorneys too. Most of the plaintiff's attorneys, a lot of these guys can't even button their shirt, right? Not that I'm so amazing. It's just the competition's a little low. So, if you're going to show up and try to do a press conference with a bowl of soup on your shirt and not having shaven for 6 days, I suspect you may not be quite as effective at controlling that narrative, right? So, bringing it back, the concept is, though, that if there's press on a case, the employer can say, oh, it's he said, she said. But that's not really much of a response in the court of public opinion, because the public loves to have an opinion. And they're just going to decide who they trust. They're just going to decide. We believe her. We believe him. It's a he said, she said. So rational folks will come to different conclusions, right? But at the point where the press has happened and people are drawing up on different sides as to who to believe, the employer has already internalized the damage of that press narrative going live. It's already out there. You can never put that back in the bottle. That genie is out, right? And so the argument that, oh, a he said, she said case is not valuable and you shouldn't go forward with that. You should take chump money on that. Chump money, by the way, is different in every case, right? Like, there's definitely cases where somebody's like, I'm giving you 20 grand, take it. And I'm like, that is a good deal. Given this case, given this fact pattern, given my client's ability to convey the story of what went on here, that could be a good deal, right? Some cases have flaws in them, and you might look at 20 grand and be like, yeah, it's a good result, right? But it's a sliding scale. There's definitely cases where $1 million is chump money. It happens. The cases are different. Plaintiffs are different. Clients are different. Evidence is different. Laws in different areas are different. There are so many different criteria and factors that can change the valuation of a case, and we have many videos on this channel about that. But to my point, right, like, whatever your chump money is on your case, don't take it because someone's telling you, oh, it's he said, she said. There's a lot of ways that that's not as meaningful as people think it is. One, it's the attorney's job to make your version of events believable to the finder of fact. Two, it's your attorney's job to make your version of events believable to the public at large if there is a court of public opinion ongoing, if there's press on the case. And that will be a source of harm that the employer will experience. I'm not saying we do that to hurt employers. I'm saying reporters do these stories and we have to fight that narrative out, right? 3, just the cost of fighting you in court is often in excess of what maybe they should be offering you in settlement. Or at least it's a good start, right? So it's worth noting that even if you have a he said, she said case, there's all these reasons why a rationally self-interested employer would try to cut you a check. So, oh, yeah, maybe we did mess up here. Maybe we did. Can we talk about settling this? What are you looking for, right? And I think that happens regardless if some lazy ass attorney, pardon my language, told you, oh, he said, she said, I don't want it. I don't buy it. I don't buy it one bit. These are just my thoughts. I've gone really long here. 2 videos on this topic, but I thought it was a really important one. And I hope that you're all having a lovely week. Like and subscribe. It helps me to help more people just like you.